Look at that. Cappuccino time here to wake me up. Ladies and gentlemen, welcome back to Guns and Gadgets. This coffee is brought to you, and this video is brought to you by Blackout Coffee. Check us out down below, blackoutcoffee.com/GNG. We have coffee, ground, whole bean, K-cups, flavors, loose leaf tea, flavors, hot chocolate, flavors, swag, awesome sauce. Check us out down below. Save 10% every single order with code GNG10. And we love the support. Thank you. New York State Rifle and Pistol Association versus Bruen. A lawsuit and decision so good and powerful. Let's play it back. Let's do it again. That's right. Another lawsuit was just filed. It's the New York State Rifle and Pistol Association versus Bruen. Same plaintiffs, same defendant. They're being sued again. New York is. Why? Because of the new law that took place at midnight this morning, last night, however you want to look at it. Their Concealed Carry Improvement Act. It's violating everybody's Second Amendment rights. It's blatant. It's obvious to see, yet these friggin' politicians think that they run the show. It's we the people, not we the politicians. Joe Biden had that wrong too. On screen is the lawsuit. I'm going to show you a couple things here we'll go over together. I won't read the whole 29 pages, but I'm going to give you a quick synopsis here. You can see New York State Rifle and Pistol Association and Robert Nash and Brandon Koch, same plaintiffs, versus Kevin Bruen in his official capacity as the superintendent of the New York State Police, and Richard McNally, who is the Justice of New York Supreme Court, 3rd District, and the licensing officer for Rensselaer County. Plaintiffs, New York State Rifle and Pistol Association, Inc., Robert Nash and Brandon Koch, collectively plaintiffs, by and through the undersigned attorneys, filed this complaint against the above-captioned defendants in their official capacities as state and local officials responsible under New York law for administering and enforcing the state's laws and regulations governing the carrying of firearms outside the home. Plaintiffs seek a declaration that New York's limitations of and burdens on the right to carry firearms as enacted in Senate Bill 51001, that's the new law in New York, and as otherwise detailed below, are unconstitutional under the 1st, 2nd, 4th, and 14th Amendments to the United States Constitution. Plaintiffs also seek an injunction compelling defendants to refrain from enforcing those invalid limitations. In support of their complaint against defendants, the plaintiffs hereby make the following allegations. 1. The Second Amendment of the United States Constitution guarantees the right of the people to keep and bear arms. The Supreme Court in New York State Rifle and Pistol Association versus Bruen, 1, made clear that the text of the Second Amendment protects equally the right to keep arms in the home and the right to bear them in public. Nothing in the Second Amendment's text draws a home-public distinction with respect to the right to keep and bear arms. The Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation, and confrontation can surely take place outside the home. This guarantee protects the right of ordinary, law-abiding adult citizens to carry handguns publicly for self-defense. 2. At issue in Bruen was a New York law that granted licenses to carry concealed without regard to employment or place of possession pursuant to Section 400.00 of the New York Penal Law, a handgun carry license, to only those who could demonstrate to a licensing officer that they had proper cause for obtaining a handgun license. The licensing officer's determination was discretionary. Bruen struck down that requirement, holding that the Second Amendment precludes licensing laws under which authorities have discretion to deny concealed carry licenses, even when the applicant satisfies the statutory criteria, usually because the applicant has not demonstrated cause or suitability for the relevant license. 3. In response to Bruen, New York enacted a Concealed Carry Improvement Act, Senate Bill 51001, the CCIA. The CCIA replaces one unconstitutional discretionary law with another unconstitutional discretionary law. The CCIA contains a slew of burdensome and discriminatory requirements for obtaining a handgun carry license, violating the 1st, 2nd, 4th, and 14th Amendments, and an additional slew of restrictions on where and how handgun carry license holders may exercise their right to carry arms outside the home, in violation of the 1st, 2nd, and 14th Amendments. So, the New York State Rifle and Pistol Association versus Bruen, Part 2 is official. This lawsuit was filed yesterday. I'll have a link down below. I always do for you guys. There are 6 counts that they're suing based off. The 6 counts where they're saying they're violating people's rights, and we know, I mean, if you have gone to any, even public schools that have any education time about the founding of the country and the Constitution, it's like blatantly obvious to people to see that what Kathy Hochul and the New York State Police Superintendent have done is about it's even more unconstitutional than the law that the Supreme Court and Clarence Thomas just destroyed. Yep, here we are, another lawsuit to tell New York to go piss off. Quickly on screen, you can see what they're looking for, where it says prayer for relief. It says the plaintiffs pray for an order and judgment. An order declaring that the challenged sections of the handgun carry license requirements as set forth above, both on their face and as applied through foregoing implementing regulations and practices adopted by the defendants, violates the First, Second, Fourth, and 14th Amendments to the United States Constitution in violation of 42 U.S.C. 1983. That's a civil rights violation, civil rights claim for those who aren't aware. Enjoining defendants and their employees and agents from enforcing the challenged sections of the handgun carry license requirements as set forth above, awarding plaintiffs their reasonable costs, including attorney's fees incurred in bringing this action pursuant to 42 U.S.C. 1988, and granting such other and further relief as the court deems just and proper. So the attempt to stop this law yesterday by GOA came that close. The judge said that this law is unconstitutional, but I don't think you have the right standing, so we're going to allow it to go through. The judge should have said the law is unconstitutional. Done friggin' deal. But, you know, he doesn't want some negative attention, so here we go. Next shot at the title is New York State Rifle and Pistol Association versus Bruen, Part 2. If you want to stay up to date on this one, definitely subscribe, because I'm going to be following this one along each and every single step to let you know if we get an injunction, a temporary restraining order, or what. My hope is that this is acted on quickly, hopefully today. That would be phenomenal, but I will stay in the know. If you want to stay in the know, subscribe to the channel, like the video, and share it so more people know about this fantastic second lawsuit by New York State Rifle and Pistol Association, again, versus Bruen. And I will, like I said, I hope this could be wrapped up quick, but judges sometimes don't do things the way the world thinks they should. So I'll stay on it. You want to stay in the know, follow me here, check back often, and thank you so much for your time. Check out Blackout Coffee, because our coffees make fantastic cappuccinos. I mean, I have a cappuccino like once a month, but that looks pretty damn good to me. I'll see you in the next one. Take care.